notarial acts. I'm Mark Comstock, member of the commission and been in the show, I guess, or at least Sandy is. In the room, let's go from there.
Right. My name is Jeannie Goldsmith. I work with the Secretary of State and Corporation Division.
And I'm Jamie Weddle, the Oregon Secretary of State Corporation Division.
Amy Zebko, Oregon State Bar.
Heather Gilmore, private practice.
Renee Alberti with Notary. I will be leaving a little bit early again and being Wednesday, sorry.
No problem.
Thanks for being here.
It's Mark Wicklow.
Greg Schrommel, First American.
Cam Levitt, Northwest Pricing Association.
Anthony Free, Oregon Judicial Department.
Marisa James, Legislative Council.
Sandy Weintraub with the Oregon Law Commission. And then we have quite a few on the phone, so it might be hard to get in order. But someone start?
Cleve Abbey.
Thanks, Cleve.
Shannon Newell.
So I got Shanna and Pat.
Melissa May.
Thank you, Melissa.
Tommy Brooks.
Thank you, Tommy.
Ken Sherman.
Thank you, Ken.
Michael O'Neill at First
Thank
American.
you, Michael.
Hi. Tim Reiniger.
Thank you, Tim.
Sure.
Like we just added somebody.
And did anyone else add, just join on the phone? Is anyone on the phone and not identified yourself?
This is Brian Marsh. I just joined.
Oh, hi, Brian.
Well, thanks all for coming, and hopefully we can get through our agenda and know what we're going to do here in the near future. So, Sandy, give us a rundown of where we've been.
Yeah, where we've been, and I'll just, because I know it's been a couple months, and thank you all for your patience with me. I just got back off parental leave. We have a 2-month-old now. He's doing great, so thank you all. But where we've been so far is we came to just a broad scope. We came to a conclusion that we were going to use Rulona as our basis for the statute, and we spoke about several issues concerning that. A couple will come back today. We decided that we had 2 opportunities to actually see presentations of an actual simulation of what it would look like from 2 national vendors, which is helpful for us all to understand what the process would look like. We all agreed to actually move forward with the statute. Marisa actually has come back to us with an initial draft statute for us to work on moving forward. And then the only other thing that we've really discussed is there's a couple outstanding issues. One of them, the discussion of the notary seal, which Tim spoke about. The other, which Heather has and Amy have given us some information on, which is not in the agenda, but we should also talk about today, are the conditions when a notary will refuse to do their action. Otherwise, I think we're at the point where we can use the draft that Marissa's put together to start the drafting process, to have us ready to hopefully have a bill to be presented for the short session coming up. I know from speaking to Channa, who's on the phone, that our deadline is coming up and to have a bill ready by late November. So this is the time of work for commission groups where we may end up meeting more than once a month if necessary to ensure that we can get the statute ready to go. But a lot of that just depends on the pace we're able to do with drafting.
So what I propose to do is have a discussion about the notary seal official stamp issue that Tim Reiniger has identified. And for those of you who've written words in front of you, that's on Sandy's reminder email from yesterday, I think.
Yep, that one was sent out at 2:26 Pacific yesterday.
And then we're going to talk about the discussion that Heather has raised on notary statute refusal language or prohibition language, or whatever that is, and see if we can suss that out a bit. So, at least as I understand the official stamp notary seal issue is that it would be helpful to have some clarification for our statutes about what an official stamp is for purposes of Rulona. Have I kind of accurately characterized that, Tim?
Yes, Mark, that is correct.
Okay.
And if you want me, I could just interject for maybe
Sure.
30 seconds or 60 seconds here. And so this issue, it's not an earth-shaking issue by any means, but I'll be frank that from two perspectives, one, I've had the honor of being an ABA advisor on the recent Rulona committee, which only dealt with the remote online notary amendment, and they were not tasked with going back with making any other changes to the underlying Rulona going back to 1980. But the other hat I wear is having been a former trial attorney. And so candidly, I have that paranoia about evidence getting admitted and all the issues around that. So really, that's why I've always taken interest in this issue of the evidence codes referencing official seals, and along the way, sometimes there's been an approach of the seal being viewed as only an embosser, and it should be called a stamp, so make it clear that's not an embossed, using an embosser device for purposes of photocopying, all that stuff. So in other states along the way, I think probably generally trial attorneys in other states have flagged this also as an issue from their perspective. So other states have shown it to be a very simple matter of putting in a clarification to remove any doubt that for a judge down the road, if there's any use of the stamp, notary, what's called a notary stamp, it also satisfies any requirement of a public official seal. And this may also have some interstate recognition issues down the road too. So anyway, it's kind of, in my mind, almost a cleanup, a tweak. And I just bring it forth as a recommendation, just for your consideration.
Well, I certainly appreciate trying to clarify things. And I looked over the alternatives that you had here in your email, Minnesota, Iowa, Kentucky, and Maryland, and Montana. And I'm one that is pretty simple, so fewest number of words, I think, is a preference. Is anybody else have any thoughts or whether or not we need this clarification? And if so, what kind of form and where to put it?
This is Michael O'Neill. I can at least attest to this conversation that took place in Maryland, and there were a number of provisions that referred to public seals and including misconduct for use of public seals, and everyone said, in Maryland at least, you're right, official stamp is not clear that it's a public seal. So they added just a short, very short sentence that said, the official stamp is a public seal. And that seemed to satisfy everyone in Maryland that took care of this issue.
You know, if a public seal is something in Maryland, we don't have anything talking about a public seal in our statute. That's a special Maryland term or other.
Yeah, there was a particular criminal code about uses of public seals, and clearly under existing Maryland law and misusing public seals, and clearly under prior Maryland law, a notary seal fell into that category, but there were other references in the evidence codes on the use of seals, and so it was felt that simple language was enough to encompass all of that. Tim, I think in your email you pointed out a couple of places in evidence statutes that codes that refer to as seal, and it's really just a terminological. You just want to get the terminology right and consistent, I would think.
Sandy, can you pull up 4510?
Sure. This is Tim Reiniger. I noticed that Mr. O'Neill made a suggestion in his latest submission that might cover it. It looks very good. You know, if there's a concern about calling it a public seal in Oregon, maybe just call it an official seal. You know, any requirement for, you know, somehow or other, a stamp includes a notary seal, an official seal, to that effect.
We're pulling up the evidence code provision on self-authentication. I'm just looking to see where it's used in this.
Starting to seal.
Okay.
So yeah, that's 510.40, if you're looking at ORS 40.510.1E, it talks about a public officer having either a seal, no seal.
Well, does anyone have any preference on the alternatives? It, quite frankly, it's ambiguous here in the evidence code, so it may be the Kentucky language that might be more conducive to clarifying whether a notary stamp is sufficient. Anyone care?
Well, using a definition like that, you have to make sure you use that term in places where you want to apply. So, for example, you might want to do it a little differently than that.
Yeah, it generally appears.
Go ahead, Tim.
Oh, I'm sorry. I apologize because I'm by phone. I don't want to appear to be rude and interrupting. Just quickly, the citation, at least I found, was and it only applies almost every state as the Rule 902 of the Evidence Code, both federal and usually the state versions. And it's just usually the provision dealing with self-authenticating documents with an official seal. So that's what.
Okay. All right.
When I was looking at all the major states that either surround us or large states, almost all of them have right in their notary code the criminal penalties for inappropriate notarization. So the reason I'm mentioning that is seems like it would make things simple to put it all in one place, but Marissa, it's really a question for you. Where do we put stuff?
Yeah, I think we'll find it. I mean, I think it would be fine to say something simple that a notary stamp is a seal for purposes of whatever statutes. I think that's fine. I just think using public seal seems odd to me since we don't talk about a public seal anywhere else. We could say an official seal, although we don't really have that either. Or just say a seal.
The evidence code says a document bearing a seal purporting to be that of the United States or of any state. So is that the notary seal?
Well, that's why I'm looking at the Kentucky language. That seems a little bit broader to identify that the stamp that is contemplated under Rolona to be changed here is also a seal, and could well do it, but I'll defer to Marissa to figure out how we want to say that.
Yeah.
Well, let me ask this. Do we have a consensus that we want to change it and define the seal for purposes of our statutes? Well, maybe I didn't ask that question correctly. Is there any objection to proposing some language to have the seal defined and include the electronic image as a notary seal? Hearing none, that's a task to be identified, and Marissa will help us identify where to put it and how to put it.
Okay.
Okay?
Thank you.
All right. Heather and Amy, you did extensive work on whether to change the language for whether our existing 194-245, a notarial officer may refuse to perform, and whether or not it should be stated as a prohibition. Heather, I'm going to ask you to kind of tell us why you think it should be.
So the truth is I'm back and forth on the issue. Honestly, I can see both sides of the debate. And so if we start at the strategic level about the knee-jerk reaction to this statute that some of the estate and elder law community may have because of the potential for abuse, I'm strategically thinking that there may be some value in actually prohibiting a notary from notarizing a document for a person who doesn't appear to understand. So in terms of do I have an opinion about it, about public policy, I'm not sure. In terms of strategically, I think that there could be some value in that. But is the strategic value important enough that we place our notaries in this position of trying to assess capacity? And that's a tough thing to do in a bank when you see the person face to face. I think it's going to be an even tougher thing to do electronically when you can't see all of the things that you see in a bank, like how a person gets into the bank, how confused they are, who's with them. So if I stay on a strategic standpoint of changing the statute to prohibiting the notarization of a notary public when the person doesn't understand, Florida has done it. Florida also has criminal penalties. We have criminal penalties in Oregon. If you look at the Notary Act on the criminal penalties, it's I think a Class B misdemeanor, and you can be criminally prosecuted for inappropriately notarizing or attempting to influence a notary inappropriately, which I think is a really interesting thing that maybe in notary training that might be something that we add in this new concept. So from a purely strategic standpoint, I think that it's good public policy to prohibit it when the notary has reasonable cause to believe that the person doesn't understand. I like reasonable cause language. I don't like the Florida bear language. And the reason that I don't like the Florida bear language is Florida statute simply says, it prohibits it. Well, that puts your notary in such an awkward spot, but reasonable cause to believe that the person doesn't understand, I think would be helpful language. And then we're just at the whim of the notary. If the person comes in and the notary knows that something's wrong and there's reasonable cause to believe they don't understand, being able to point to the statute and saying, I'm prohibited from doing this, I'm sorry, I can't help you, I think has some value public policy-wise as well as strategic for this legislation.
Well, I'm going to ask our friends from the Secretary of State's office to say, what's the training and what is your preference as the regulator, if you will?
Right. I was just looking to see, as far as our training, what exactly it is that we say. And I know that we do have a little bit that we do. We have two different trainings that we do in person. One is a basic training and one's a more advanced training. And the advanced training, I know that we go a little bit more into detail on how you can be able to, different things to look for, different signs to look for the notary so that they can feel confident to make sure that the person that they are notarizing for actually knows what it is that they're signing. I know that when we can only do so much. I mean, as far as what the training is, I can say that a lot of times, we have notaries that they are doing this because they are told to at their job, and so it's really, really hard to. You can give the training, but I know how far that really gets us a lot of times. Just knowing the questions that come in to us, but we do, say about the different signs in our training. We talk about the different signs to watch for. We talk about, if there's somebody else with the person, and different things that you can do, like having one person leave the room. So we talk about all that stuff, and we definitely do that in all three of our trainings.
Do you think having language that's advocates saying I'm prohibited from notarizing this because I don't think you have capacity, do you think that would help those individuals who are doing it as part of their job responsibility? Give them some pushback against those employers who might be forcing them?
I think that definitely could be something. I have liked using the wording, they shall not instead of may not.
May refuse.
Yes, or even may refuse. But I think no matter what wording you have, if there's a situation where there's a family member who is trying to get from their elderly relative, they're going to complain or push the issue no matter how. If they really are not in agreement with the notary, whether the notary refuses or the notary does it, I think we're going to have the same issues both ways.
Let me ask this, from a regulator standpoint, how many disciplinary proceedings has the Secretary of State done in relation to notarial actions that may or may not be appropriate?
Trying to think. I know that we have a couple right now that we're working with complaints that have come through that we're having to evaluate. We might, maybe a handful a year, maybe, if I had to guess, 6 to, average is maybe 6 a year or so. And that's for those types of situations.
Do you have the ability to discipline them for notarizing a document when the person wasn't capable of understanding? Because the way the statute's written, it seems like it's not actually prohibited. If you look at the language, not prohibited.
Usually there's other things associated with it too, when we go in and start actually doing an investigation. So we have to look at an entire picture. So that one little piece may not be exactly what we're going to look at. There's usually something else too that we're having to go with. And basically all we can do is just say, see what the notary action is on it. Probably more the case would be that they are saying the person wasn't there, and the signer actually wasn't even in the room when the notarization was done, or that type of thing. So then we're having to have the notary, give us a lot of information, their journal, so we can review that, and giving them questions that they have to answer for us.
So I think one of the benefits, at least in my experience, is that the remote notaries have the ability, if you're comfortable, to say, no, I'm terminating, I disagree, and then you also have video. I think I would be worried if I were a notary, if I now am prohibited, and I actually thought they were, and it was laws written in a way that it's a prohibition. I know I violated the law, and I'm on camera, but I really thought that the person was equal. And I really walked through the questions, and there are scripts and questions that we train our notaries, obviously not everyone's the same as us, but there's extensive training, and notaries feel comfortable. So I would be worried as a notary myself, if what that means for me if I do.
Would you be more likely to not notarize something if you were electronic?
Yeah, because you don't have that pressure of.
I agree.
I agree with you. Like, I can't, no, my mom's good. She can sign this. No.
Yeah, but then you don't always have to deal with them in your bank lobby. You can just say, I'm sorry.
And then one of the first funny things to journal is usually if you're terminating, why?
Yes,
For a reason.
you have all your
And then you also have the
documentation.
video.
The problem, they would just go, someone that wants to be forced will just go to the next notary down the street.
They do, but that's not a good public policy reason for our statute not to change. It would be interesting if grandma gets taken from, first they try to do it remotely, and then there's a record that they tried to do it remotely, and then they go to Bobby at the UPS store. And it's true that that's an issue, but the cases that I have had problems where it's clear the notary should not have notarized the document are a hospice has a list of notaries that makes house calls or hospital calls. And those are very worrisome cases to me because I actually had one of those highly experienced notaries tell me, my only obligation is to verify the identity of the individual. And that's the perspective out there of a lot of notaries. And I think we're at the point in public policy that we have to ask ourselves, is that really our only obligation we want to impose on the notary? Because there's no statutory obligation that they confirm the capacity. Zero. And if we change it, then there's some kind of obligation that they have use good judgment.
Well, let me ask the question then. Picture yourself in a real estate closing where grandma is being asked to execute a transfer on death deed, and she can't really explain what the effect of a transfer on death deed is. Is that an example of not having the capacity to do it, and then everything's terminated?
Well, the Florida statute says you can't notarize something the person does not understand.
Well, I mean,
Most people don't understand any mortgage document.
Yeah, a mortgage document, I agree that it's like, you can understand this puts a lien on my house and I have to pay you back.
Yeah.
Or on a transfer on death deed, if you can understand it's your house until you die and then Bobby gets it, I think that means understand, but.
Yeah, the notary shouldn't be explaining necessarily all the paperwork involved, because everything should be there for them to just, is this what you agreed to, and just review it. And if they have a lot of questions, on a lot of the platforms, you can have another person phone in, whether it be the lender's contact or the title contact, to make sure that they get the correct answers. So that should be available where, kind of today, especially if you go to someone's house near the notary, you have to wait and have someone call them on the phone, where you can always get everything together and the video.
From the title standpoint, is this a potential roadblock to efficient closings? I'm simply asking the question, and
A roadblock. This should be the same as today, where if you have questions, the client needs to be able to call somebody, and that exists today in the paper world too. This just makes it so that if you call someone else and have them join the conference, they're included in the recording. So you have everything that was said between all the talking heads.
Okay.
I was deferring to Cleve, but,
Oh, we can call out.
I think our perspective is we value the scrutiny of the knowingly and voluntarily made, because we are typically insuring those conveyances, whether it be for conveyance of the fee or the conveyance of property as a pledge of security. And so when we train our notaries at First American, and I assume it's pretty similar across the industry, we want to make sure that those escrow officers who are our notaries are looking at the capacity of the person executing the instrument. And so having other notaries with that same training and obligation is comforting from a title insurance perspective. With respect to your example on the transfer of debt deed and understanding the entirety of what that instrument does, I'm telling you that it's not a good example, because usually they're probably going to go to the attorney and the attorney is giving that option as a tool in their estate plan. The question is, do they knowingly, from our perspective, knowingly, voluntarily know what they're signing when they're doing their sale to, you know, Bob the buyer, or pledging their property for so I like the idea of either the prohibition or the may refuse. My first practice was in Washington, so I like the Washington style. That's probably just because of familiarity.
Oregon already has may refuse, but no prohibition.
And
I can sort of speak from a national title mortgage perspective. This is Michael O'Neill at First American. Putting a prohibition is a minority rule, but it's one that's been taken by half a dozen states or so. And we've never developed a position, pro or con, about states that have decided to include that duty to actually screen for voluntariness. And so we don't have a sort of national position on this, and have extensive experience doing notarizations in states that have a prohibition, and we're complying, and our notaries are trained, as Craig was saying, we train our notaries to the same standard regardless of whether it's an affirmative statutory duty.
Okay. So I guess this is to everybody, do we have any preference on whether we stay where we are, which is may refuse, it's permissive, and appears to be similar to what the standard is in Washington, or do we want to go down the minority path, which may be a trend now, but where do we want to end up on this?
This is Ken Sherman. I'm just thinking about bankers who offer notary services, and I haven't discussed this issue with members of my client, but I'm guessing that tightening this up will kind of advance the trend within the banking industry to refuse to provide notarial services, except in pretty limited circumstances. A lot of the banks now are saying we won't notarize for somebody who just comes in off the street. You've got to be our customer. And a fair number of them are now saying we won't notarize unless we are actually involved somehow in the transaction for which the notarization is being accomplished. And maybe that's fine. I don't know the extent to which people in communities around the state are looking to the financial institution, bank, or credit union or whatever to provide this service. But I would think that if you say you're prohibited from doing it, if you have some question about whether the person understands, that's going to create a potential liability for financial institutions that they're going to be pretty reluctant to accept.
From the credit union?
Well, we had a similar situation in kind of the elder abuse area too, is, as Ken said, Obviously, you want to protect, in our case, our members, but you do have some liability when a teller is making, or a account manager is making those decisions, and there is some concern about liability. So I agree with Ken, although I haven't talked to our folks about this issue.
Ken, don't you already have that liability under 124, the innocent bystander statute?
Under 124,
That's the civil elder abuse action, which basically if you knew or should have known and you didn't do anything and you allowed it, you're civilly liable. I think that's.
I haven't thought about that, but.
Sued on that, by the way.
Yeah.
Effective.
We may very well have some liability in that area, but I'm really focusing just on the provision of notary services, and I'm just offering the observation that I think passage of this may very well encourage financial institutions not to do this except in a very narrow context. And that may not be a good reason not to do it. I'm just saying that's what I think will happen.
So for people who might be from out of state, Oregon has a statute under ORS 124. It's an elder abuse statute. It's one of the most aggressive elder abuse statutes in the nation. And it says if you knew or should have known that a person was being financially exploited or harmed, then you can be sued for elder abuse. And elder abuse in Oregon is automatic treble damages plus attorney fees. So it's a huge chilling. I think that the statute has a huge chilling effect on a lot of things that otherwise everybody would say, hey, that's just the way it is. But you don't even want to defend your client against an elder abuse claim because the consequences are so extreme.
I'm not as familiar with the statute, so would that already obviously apply to a notary present day then?
I believe so.
Yeah. I've done right now.
Yeah. Why, if you knew or should have known and you facilitated it in some way, and I have personal knowledge, not me, but the lawyers in the community are really successfully suing and being sued under the statute in the Oregon Professional Liability Fund, which is the insurance company for all attorneys in Oregon. They're aware.
I just wanted to reference, I was referring to some past legislation on mandatory reporting for institutions, which is different than current statute.
Yeah, this is civil liability is what we're talking about. But Ken, I agree with you that it's going to make the banks less willing to want to notarize, and I'm not sure that's a good or a bad thing. I honestly don't know whether it's a good or a bad thing.
Neither do I.
I hear a lot of that right now, but also, there's approximately, I think it's 40,000 notaries in Oregon. So it's not, there's a lot of them out there. Might be another thing to think about.
Well, do we have strong feelings about whether we should change or suggest a change to make it definitive? Or should we punt to the Secretary of State's office to maybe do that by rule, or what's your pleasure?
This is Tommy Brooks. I just wanted to add just one other perspective to this, because I think I'm inclined that, a good policy is more to let the notarial act be one of identification and not of determining capacity. It occurs to me that a lot of my clients are public entities who the person doing the execution of a document isn't actually the one making the decision. They've been authorized or mandated by, for example, a governing board to proceed with a transaction. So like the board of directors will say, we want to sell this property. We want our general manager to go sign this document. And so when they get to the signature or the execution of that document, really all we're establishing is that they have the authority to do that from the person making the decision, in this case the board, and who they are. And if there is any question about their understanding of the transaction or legally, if they have capacity, it's almost like it's irrelevant. And so it's a completely different context than I think what a lot of people on this conversation are used to dealing with. And I think like the elder abuse, all that's very interesting. But in terms of kind of a one-size-fits-all, I'm inclined to say just that the act of identification and not making a legal determination about capacity is kind of where we should stay.
I agree with that.
So the Florida statute says the person is mentally incapable of understanding the nature and effect of the document. So in your example where the manager shows up to sign, it doesn't mean that they're mentally incapable. It just means that they don't know what's going on, not because of lack of capacity, but because of an administrative role. Yeah, I mean, capacity means like, he could understand that he's been directed by his boss to sign the document. He doesn't need to understand the document if he's signing it on behalf of the boss. But it's another thing if you don't know why you're there that day.
Well,
right, and I wonder if we put a notary in that situation of having to make that judgment call of which situation it is. It strikes me as a much bigger burden than what they might feel like they have now.
Yeah, I don't think they're analogous.
Okay.
Will notarial errors and omissions insurance cover a notary for this? But that's the only other thing to think about is a notary, you're going to have some, hopefully, if you're smart, you've got errors and omissions insurance. I guess maybe just something to think about. If I'm a notary now, I'm opening myself up again. I don't know.
Right, and the notary, it's not, you don't become a notary, your commission doesn't belong to your employer. The commission belongs to the notary themselves. So they do take a lot of the responsibility as well, and they should. They also should, I believe, we do have a lot out there that are notarizing all day long, and they're just doing it, they're paying a stamp and they're signing and they're saying, okay, I'm done. And they're not paying attention to what they're actually having the person notarize. So to me, I go back and forth on it, but I do think that maybe we should be putting a little bit more responsibility on them. And if you want to be a notary, then you have to be paying attention. And maybe this changes that. Not that that's what I'm saying, that we should be going that way, but it gets a little bit frustrating when you hear these notaries all day long. They're like, we're sending advice letters all the time. Like, don't just stamp and sign the document. There needs to be a certificate. What are you trying to do with this document? They're not, paying attention. And we have a lot of that going on.
Well, let me ask this question, and it's simply out of ignorance. Does a court clerk, somebody at the counter at the courthouse, which notarizes something, do they have to be a notary, or is it they are certifying something because of the office?
They are certifying because of the office. They don't have to be a notary.
So they don't have to be a notary?
No.
Okay.
I'm looking at this, Ken Sherman, I'm looking at the definition of notarial act, which is in 194-215. I don't see anything in that definition that encompasses determining whether the person who's signing something is competent or understands it or anything to that effect at all. I think we're really we're talking about expanding the responsibility of a notary in the typical situation quite a ways beyond what we have historically considered that responsibility to be, which is to verify the authenticity of the signature. And I'm getting more and more uncomfortable with the idea of changing 194-245. I think it's good that our statute now permits a notarial officer to refuse to notarize in the circumstances described in that statute. But I think if we if we're going to prohibit them, then I think we must necessarily redefine notarial act, because right now that definition doesn't include anything that would speak to a notary's responsibility or even authority to determine competency, et cetera.
This is Heather, I don't disagree with you in any way, but that goes back to my original comment about strategy. So maybe we just ignore changing the prohibition and proceed, and my concern is if we do that without a token, that we're going to run into some challenges.
Well,
Maybe.
my response to that is, I think that might be beyond the charge to this work group, and what the commission has authorized us to do. That's one thing, the change in to make it a prohibition. But also, I think that remote notarization needs to stand on its own merits. If it is a good platform and provides some additional evidentiary information to the courts, I think that would carry the day for dealing with remote notarization. So I do consider Ken's suggestion here to be pretty valid. And I think that unless somebody wants to make a motion to do that change, we'll have ourselves a vote. But I'm thinking that the consensus is we don't want to go to that prohibition.
We don't want to add that extra obligation for a notary. And I don't disagree. I just know in my prior experience with legislation, I just know what the natural consequences might be. And maybe those battles are over. Maybe those energetic, involved persons are no longer feeling energetic or want to be involved. But I just know that it is what it is.
Okay. Well, let me state it this way. Is there an objection to not changing 194-245 to a prohibition? Hearing no objection, let's move on.
I think we're at the draft at this point.
I think we are at the draft. And we've provided to you the draft from Marissa.
If anyone would like a hard copy, I have them.
Now, do we want to have Marissa kind of walk us through it?
I can do that. It's basically just the sections that you asked for, so, yeah.
You need to walk through that, okay?
So.
Now, there were comments, so let's just say it's the Rulona language, but there were some suggested comments that made some sense, in at least my mind, and I think it was Tim that maybe Mike would.
Yeah, we got one from Michael, and then we got one from Renee. And I shared both those documents. One thing I could do moving forward after the initial meeting is I could just share a document with everyone that everyone could make comments on as well, which might be easier too.
Well, let's do this. Let's have Renee kind of tell us what her concerns are, and then we'll go to Mike.
I
Okay.
think my comments looking at Michael looks like they're similar, so Michael, feel free to chime in as I kind of go along. I think the first area was in section 2, number 10, was that optional language that the OLC had left in, again, optional was added during the final hearing and approval. So I was registered because I wanted the first question was, the Secretary of State will come and be the process
we want this to have a zero financial impact, is that right?
We prefer
Yes.
it that way. It's easier to make the argument that this is good policy.
Also makes it a much easier process with the legislature.
Yeah.
Would Section 10 add dollars to it, do we know?
Oh, you bet. I think the Secretary of State would say, we need an increase in our budget to be able to do this.
I think you're right.
Okay?
So, and also just quite honestly, it's pretty overly broad, because it doesn't even narrow it down just to a notarial act that occurred in Oregon. So it is quite a burden, hopefully we're not receiving a ton of, it doesn't have to receive that many, but it is quite overly broad. There's a better way, I think, to try to accomplish what I think we're trying to accomplish, but,
Well, assuming that a remote notary practicing in Oregon is going to have to be first registered and to be able to do business, so they're going to be subject to process anyway.
And they should be, you would think they would be registered in Oregon, and then the service of process goes under the normal way that we do it now, where they have a registered agent that's located in Oregon that would need to be the one that gets served, and so then we already have that process in place, as long as they would need to register. It would not be us unless they've exhausted, it's a process that we have now.
okay.
But it's business registry, not a separate process a different process for notary. So as long as they were needing to register their business, then we would already have that in place and we wouldn't need to make any changes.
So could the legislative history just say that a remote notary must be registered to do business in Oregon? Do we have a legislative history?
Creating one.
Right, you would want,
Not the notary, but the company.
Nevada did something similar, they did it in their rules, that made it not changing, but, something we're not supposed to do.
Yeah, if they, if they're doing business in Oregon, they should be registered, and that's now, I mean.
That could just be in the administrative rule.
Yeah, that could easily be done. I mean, the example is, I had to probate an estate in Virginia, and I have had to engage a company to be my registered agent in Virginia for that estate. That's, $191 a year or whatever it is. So, that's easily taken care of, I think. Anybody in favor of keeping this item, subparagraph 10, in the proposed statute? Michael, I didn't want to cut you off. Do you have anything you'd like to add to the discussion here?
No, I think this discussion's covered it. This provision was put in a concern that a particular state's doing business requirements for registering as a foreign agent, or perhaps their long-arm personal jurisdiction statute wasn't strong enough. And this was just boilerplate brought over from another uniform law as an optional standard. But my experience in these discussions in other states is that the combination of the personal jurisdiction statutes and doing business requirements have well more than covered what would be the concern here, because certainly a platform that is reaching out to doing business with Oregon notaries located in Oregon and providing them electronic services, that just falls squarely within all the other statutory requirements. So just providing that little bit of background, this was more of a, well, what if there were a gap, possible type solution. But I have not ever, I did not concede that there actually was a gap when this was proposed, and I've not seen anyone point to an actual gap that needs to be filled here.
Okay. Well, let me ask this question. Is there an objection to deleting paragraph 10 of section 2? Hearing none, move on.
Okay.
Commissioner, do you have one?
Okay.
Section
Renee?
10 is no more.
You had other items on your list here.
I had added in here, section 4, and it was added, to 194,401, and it had expenses at the end that basically, that except that a notary public may charge a fee not to exceed $25 for a notarial act, ultimate state for a remote notarial act. And then, essentially, what I'm going for here is the fact that most other states, it's been consistent across all of the states, they've increased the fee, they allow notary to charge $25, because now they're going to have to pay to use this technology. And it has been pretty much standard across all 22 states, that it's $25. So, again, taking into account the technology, the capturing of the electronic journal, the capturing of the audio video recording, and then going to storage on behalf of the notary public. Chances are they're not going to have to hold all those things themselves, so they're going to have to, and you don't want them to do themselves, they probably don't want to back up and try to do all those things, so. Just goes to pay really for most of the technology.
Well, let me ask this. Why wouldn't that be more properly dealt with in Secretary of State rulemaking?
Because here it says that this fee may not exceed $10 already. Is the rulemaking allowed to overrule that law? I'm sorry, yeah, I can read the whole sentence. It's initially the fee of the notary public may charge for performing notarial act may not exceed $10 for a notarial act.
Understand that may need to be tinkered with anyway, but why should we set a maximum in the statute?
You should set the maximum in the statute because you already have a maximum in the statute, or are you talking why just remove it altogether and allow them? I mean, we could do that.
What's the Secretary of State's pleasure?
It's easier to make adjustments in rule if we needed to, rather than statute. So if we had the fees in rule instead, and there needed to be a change, you know, a year into it, then wouldn't it be easier to change it that way than it would be to have to revisit the statute?
Well, I certainly think that changing administrative rules is a whole lot easier than changing statutes. So acknowledging that we'd have to do something with the $10 fee there, from a legislative council standpoint, is it just as easy to punt to the Secretary of State rulemaking?
Yeah, I mean, you can say, you've got a couple options. I mean, you could say the Secretary of State, you know, shall set a maximum, or may, you know, authorize a notary to charge a fee. There's different ways to do it, so.
I don't know, I think the maximum should be set. People tend to, if their notary is their only business and, they can just have a good old time, let me charge this fee. Of course, someone would have to be willing to pay it, but I think setting a maximum would, control people a little bit more so that they don't go off the rail. Oh, I'm gonna charge $50 for this, but really.
What's happening out there as a practical matter, in my experience, is that the notarial fee is $10. But if you read the 194,400 on fees, the notary is allowed to charge an additional fee for traveling. And there's something that I see is called an accommodation fee. And I've seen, you know, $100 for that.
So don't need to travel to do remote online.
So I'm just saying that's what the statute currently says. So maybe we should say a notary may charge an additional fee for traveling or for electronic. I mean, if we're going to put it in the statute, maybe it should be there, but I don't know. It's just a comparison of the current statute.
And for all on the phone, Matt Marquis has joined us in the room to weigh in.
Sometimes also legislators get a little hinky about saying if all the agency has authority over agency fees. So that could be some potential legislative pushback.
From a legislative perspective, is that likely to be an issue or not? I'm just not being as familiar with them.
What Amy said, I think,
Amy,
I think that
kind of hit it on the head there.
So.
They're gonna say probably a statutory maximum would be just fine, but what that number is going to be is up for debate, I suppose. I have no problem with the 25 that's kind of at least indicated that that's pretty standard across the nation, so I don't have a problem with that.
Do we need to go back and say something in 194-400 then? Or do we just ignore that?
I think we have to do something.
Yeah. If you actually look at the email I sent yesterday that includes Renee's comments, that's actually what she did.
Okay.
If you take a look. Did you get that, Marissa? Okay.
Did it really?
Yeah.
I had it in for next week.
Okay, great.
And Marissa just commented that that's done in the style that would be appropriate. Good.
So let me ask it this way: is there a consensus to add a section 4 as Renee has kind of identified it in the statute, in the draft?
And we'll add that to the main draft if there is a consensus.
Mm-hmm.
Does it make sense, because you did make the point of changing statute can be complicated, does it make sense to index it some way, or is that just a level of complication that's unnecessary?
I think indexing is a level of complication not helpful.
Okay.
Yeah.
Since there's no CPI now or something.
We have a new one. We have a new CPI.
Okay, good. Okay, anything else, Renee?
I think the last one, and I know this might be the same one as well, there was no effective date that I put up. So I suggested January 1, 2021, but putting the conversation started, how much time do we use for rules? It sounds like the Secretary of State's office would like to make rules. Hopefully, we'll be able to provide some stuff from the mid-scope group and what everyone else has been doing, but it kind of gives it ish, depending again when it's enacted. Just wanted to get that conversation started.
Well, in Oregon, at least my understanding, if it's standard legislation in a standard term, it takes effect the following January 1.
Unless there's an emergency.
Yeah, exactly, and I was going to say, I don't think there's a need for an emergency clause here.
Legislators are very anti-emergency.
Yeah, the only thing I would suggest though,
Hey, Mark?
Secretary of State's perspective is, but if they need rulemaking before the effective date, we may want to put something in there to allow them to do rulemaking before the effective
Like
date.
in that case, we need an emergency clause, so, yeah, so.
So I think Michael, didn't you suggest language in your version allowing for rulemaking before the effective date?
Yeah, if folks want to bring that, my comments up, that's kind of the approach I was thinking.
You can't do it that way, I mean, until the thing becomes effective, it can't say you can make rules about the law that's not effective yet. So the way we do that is with an emergency clause or a 91-day effective date sometimes, and then the provisions become operative, later down the line. So
Yeah,
if you don't want an emergency clause, you could let the bill become effective January 1 and then have the provisions become operative July 1 or something like that.
This is Ken, Chairman. This is one of the comments that I wanted to make. I think we need to add that language that I've seen in a lot of bills recently that establishes both an effective date and an operative date, and they should be separated by enough time so that the Secretary of State has the time to make the regulations, and then those who are out in the field that are going to have to comply with them and get up to speed before the operative date. So I don't know whether that's 91 days after the session would be the effective date, and then January 1, 21 would be the operative date or what, but something like that I think needs to be done.
Okay, what kind of timeline does the Secretary of State office prefer?
I would say, I agree with what we just, that part where we would have the operative versus the effective. I just feel like I probably would need to just be able to go back to, because we have a new director in our division now, and I would probably want to bring her in on some of that too, just so that way I'm not causing trouble for myself.
Understandable. Well, but would it be appropriate then to have kind of the hybrid approach that Ken suggested, and that would be, it's effective on January 1, no emergency clause, but it becomes operative 6 months down the road or whatever that might be.
I think that sounds really good, actually.
If we
that
do
would
this
be okay.
in the short session, would it make sense to give you guys an entire year? I mean, I don't want to delay too much, but I also think if we're doing it in the short legislative session this spring, then it would become operative at the same time all of the other ordinary session bills became operative. But again,
in that case, giving a year would be nice.
I don't know, Samantha.
I mean, it's time you need, yeah, because obviously you're going to have to make changes internally. We can help you with all the rules and give you all the materials, but if you have to make changes, a year. So
I think an emergency clause on a short session bill is not.
I think we understand.
Like, what kind of a notarization emergency are you guys having?
Bring more eyes to the bill.
So, Matt, you're looking.
I'm fine with it.
Well, let me ask you this. Is there an objection to having a standard date for the effectiveness of the bill, but having a implementation date, I guess, at least 6 months?
I mean, you can have your rules ready to go, you know, I mean, but you couldn't adopt them with statutory authorization until the thing becomes effective. So, yeah, so it's not like you can't ever talk about it in your office until January 1.
How it worked for many, many years.
I really hope in most of the states, even if there is a full year of rulemaking, even when it goes live, it's not going live right away because everyone's still working out the kinks and how it's going to be. So the hope is there's a whole bunch of states that come online on January 1, 2020. Well, it's going to still take some time to get noticed, you know, like our commissions or have their registration for remote online notarization and thing with registration around. So, you know, we will have people knocking at the door, but we still have to process everything. So.
Well, even if a bill gets presented, it's not going to be effective until January 1, 2021. Isn't that correct?
Oh, right, yeah.
So, that.
Years are going by faster.
Yeah. That gives you time to get it figured out.
So you would be able to hold like a task force group so that you can get industry folks involved in giving advice and, you know, take what you want and move forward before the effective date.
Right.
But that's sort of what we've been seeing. As soon as something has been signed, folks are, you know, sending to help out the Secretary of State's office. It's a lot of work.
Okay. Is there another part of Section 4? I guess I'm looking at Michael's draft. Anything else, Renee, or?
No, I think that was it from my perspective, so.
Okay. Am I accurate in stating that we have a regular, we don't have an emergency clause on any proposed language, but we do have an effective date that is at least 6 months road?
An operative date,
Okay.
to be clear.
Whatever the proper term is there. I'm going to defer to Marissa on that one.
Do we want to set one now just for the purpose of the draft? What that date might be?
Typically, we would see July 1,
Sure.
2021.
Okay.
And then you can always, you know, change that before.
Sounds good. So you're okay with that?
Yes.
Okay.
Anyone have an objection to a July 1 operative date?
The The only comment I would make is that it's going to be key as to how quickly the regulations are adopted, because what folks in the field need is some time to get up to speed with training and so forth. So if the Secretary of State's regulations are adopted May 1st of 2021, that's going to put people in a bind. I don't know how long we can expect that it will take the Secretary of State to do these regulations, but I just think it would seem to me that it shouldn't be a problem to get those out by, fairly quickly, but I just don't know what the timing is going to be. But there will be a need to train people up to comply with this statute.
Well, agreed, Ken, and I think that at least as I interpret the representatives here for the next 6 months is workable.
Mm-hmm.
So let's use July 1, 2021 as the operative.
Well, if the bill doesn't take effect until January 1 of 2021, that's 6 months, and you haven't even gotten to the regulation yet. The regulations get adopted after the effective date, if I understand things correctly.
I agree. So if regulations come out June, which would be 6 months.
I would recommend that we go with an effective date that is 91 days after the end of the special session or the 2020 session. There's no reason to wait until January 1 of 2021 to get to the effective date. We can do that more quickly, which will engage the Secretary of State in rulemaking more quickly, which will allow us greater comfort in a mid-2021 effective or operative date.
So the reason we do the 91st day is because then you don't have to have an emergency clause.
Correct.
Right.
So what I'm hearing, just for note purposes and working with Marisa to make sure it drafts right, is 91 day. What Ken's proposing is that the effective date would be 91 days after the end of the special session, short session, sorry, and then the operative date would be 6 months after the end of the, is that correct? So that'd be July 1?
No, I'd go with the July 1, 2021 operative date. But by doing it that way, you're going to give the Secretary of State probably at least 9 months between the end of the session and or 6 months, I guess, after the 91 days. To come in with the regulations. The regulations should be done by the 1st of 2021, and that would give people in the field 6 months to get up to speed.
I'm looking at heads nodding in the room. I'm taking that as affirmative indication on what Ken proposes here. Okay? And Marisa can certainly draft up what needs to happen on that effective date.
And I'll get that around to everyone before the next meeting, and if it looks, check it out.
Michael O'Neill, you had some other suggestions in your version of the draft. Want to kind of identify what has not been discussed yet?
Sure, yeah, I think the vast majority has already been discussed, and really my comments tended to be mainly around all these questions of implementation, so I think we've pretty much largely nailed that question down in rulemaking. The only question out there is whether we wanted to specify what rules. There's a laundry list of rules that the Secretary of State can do, but did you want to specify that rulemaking, this is going to cover certain topics and is permitted to cover other topics? I just suggest that as an approach that Idaho took, so that it was clear, kind of from the statutory standpoint, what at least the minimum topics that those rules were going to cover. But I can tell you, Washington and many other states that have passed this have not done that specificity. And if there is going to be rulemaking, I don't think there's a necessity necessarily to follow the Idaho model of prescribing what is going to be in those rules. So I just throw that out there for really informational purposes for this group.
Okay, I think that well, I guess I would prefer that the legislature not intrude on discretion of the Secretary of State on doing its own rules. So I think there would be pushback potentially if there was that kind of direct intrusion into the discretion of the Secretary of State. But that's just my thought. So I think I'll leave it up to the Secretary of State when somebody is advocating that the direct Secretary of State do that ruling. Okay? Now, Michael, you also had there was some discussion about, I think, whether a person or the county clerk should be directed to record documents. Am I correct?
This comment was sort of clarifying the purpose of this provision, what's colloquially called a papering out provision. And it was really addressed to the issue of recording documents in land records. So being able to record deeds and mortgages in tangible form, in other words, printing them off onto paper, if for some reason they were not able to be recorded in electronic form because of a system was down, for example. And you didn't want to have a choke point where an electronic recording process was not available, but you couldn't get your deed or mortgage recorded because it exists as a PDF and there's no statutory authority for that to be printed off onto paper as a certified copy and get recorded in that format. So that was the purpose of this so-called papering out provision. And the comment that I had was, given kind of the limited scope of the problem that's trying to solve, namely really land records recordings, one concern that I had of using the word person is it kind of it would apply it to essentially, I guess, any government office could fall under that definition. In other words, it could be expanding the scope beyond what I think the intent was, which was to deal with kind of a very specific real estate recording issue.
Okay. My concern, I guess, is I want to make sure that county clerk is the correct term, because I don't know that is universally used in all 36 Oregon counties. And
the county clerk is a person in statute, and they record the deeds and the mortgages and keep the office of the county clerk.
Yeah, I use the term county clerk because that's what's used in the recording statutes.
Okay.
And that's the statutory reference there is to the recording duties of a county clerk.
Okay.
It would make me a little nervous to put that statute in. Are you sure there's no other places where the county clerk is directed to record something?
Yeah, that's a very good point. So, it was not drafted to include that. I was mainly doing that for specifying, we don't want person, we want it to be the real estate recording process, but it's a good point that the duty to record may be in another statute.
Well, I certainly think that if that's the right term, then we should make sure that it's designated.
We got local real estate experts on the call and in the room. Just feel free to chime in, any of you, to make sure that we're getting this right.
What if we just said a person who is authorized by other law to record documents, blah, blah, blah?
Yeah, the issue with using a broader phrase is that there could be other government agencies that then are swept into this, and I don't know if that's a good thing or a bad thing, but it certainly wasn't the intent of this provision to apply to anything except the real estate recording process.
I see. Well, if we're just worried about real estate, I would think county clerk does it, but.
You record, I think that would be the same thing, right? And then other, like the UCC, they're recording of other than real estate through their UCC.
Well,
Security interest?
that's provided for, in other statutes for a fixture filing, UCC. And it's done, it would be recorded by the county clerk in that instance. So I'm not seeing a problem with county clerk, and I am mindful to be limited in what we have, the breadth of what we do here. So, is there a consensus, or let me say it this way, is there an objection to the language, deleting the statutory reference in what Mr. O'Neill has put forth here? Hearing none, let's move on.
You have that, Marissa?
Okay. Any other suggestions, Michael?
No, that covers it. Everything else in my red line suggestions we've already talked about, so that's great.
Okay. Anyone else have any suggestions?
This is Ken Sherman again. I've got a couple of things that I've been thinking about. I don't think either one of them really affects the draft at all, but one is, what is the impact of the Real ID Act and Oregon's implementation going to have on this whole notarial process and identity proofing and so forth? Oregon is in this process now where the DMV is going to start issuing the Real ID Act compliant driver's license, I believe in October of next year. That will not become the exclusive drivers or identification because people are not required to do that. They just have that option. But as far as I could think this through, I didn't see that fact, that developing technology and so forth would have any impact on the wording of the statute, and not just in terms of remote notarizations, but all notarizations. But that was one thing. The other thing is, it seems to me that under this act, a notary is going to have to maintain an electronic journal in order to perform remote notarizations. And I did an inquiry here in our office. Nobody's got an electronic journal. I don't know how many notaries out there in the real world are using electronic journals, but it seems to me that that's just one thing we should be aware of, that unless I misunderstand the way this works, because the notary and the person who's being notarized are in remote locations, there will have to be an electronic journal. Does everybody agree with that or understand that?
We're following what you're saying, Ken, and I'm gonna split them up a little bit here.
Yeah.
And I'm gonna defer to our experts here that deal with remote notarization all over the place, and where other states have Real ID already enacted.
Right.
So the Real ID is not an issue. It just means an additional type of look, feel of a credential that the system needs to ensure that it's updated and the algorithms are working. So it hasn't been an issue.
Anytime the state changes the look of their IDs, our systems would have to be updated to, well, that's the Real ID.
So it's more of a vendor issue? Yeah.
The large national, international vendors who do this all the time. But yeah, to your point, it's a good thing to think about.
Yeah.
Ken, because when they did, this is Heather, when they did the examples of how they notarize, that was really helpful. It's like they take a picture, you hold your ID up to the camera, and they take a picture of it on both sides.
Right.
And it's not an issue if Oregon has two separate ID cards?
Nope.
One
a lot of states have different ones. Like Arizona has two different looking ones now.
Right.
Okay, so I think that issue is not really an issue, but it's good to have the discussion. And about the electronic journal, I'm going to, again, defer to our experts here. Is this going to require electronic?
That was actually my question, is that it doesn't reference the journal in it, but I know that Oregon requires the journal now, and we now have the electronic journaling failed on the state, so I want to make sure this follows the state rules, that the same information is taken down.
So I guess every system itself should be creating its own version of an electronic journal. There's all those audit logs additionally. So, and each solution provider is different. Some solution providers say, take your data, go and get your own. There's literally an electronic journal provider that you can download a mobile app and, do your own electronic journal. From our perspective, we hold that electronic journal when they leave, then they can take it with them. They can request it at any time. That way it's at least encrypted and we know where everything is at, just from a security perspective. So yeah, an electronic journal is a must in every one of these systems. Again, when you get into rulemaking, that's something we'll touch on, is what should be in that journal.
Did you feel the language around the, like the agent, whatever, is not something that you guys?
Yeah, it's on it.
Seems like statute already contemplates an electronic journal.
Yeah.
Okay.
Yeah.
So I think that the answer to your question on electronic journal is yes, under this new act, assuming that somebody wants to be a remote notary. So, and seems that would be taken care of in rulemaking. So I think that issue is not a roadblock at all to this.
No, I agree.
Okay. Anything else on your thoughts, Ken, or anybody else?
Oh, that was it for me.
Okay.
This is Cleve Abbey. One thing that I thought to bring up is in an earlier draft that Michael O'Neill worked on, it had a couple of sections that were in the nature of curative acts, essentially section saying if there's been an electronic recording before the new legislation kicks in, they're still good documents. And I think some, particularly with the passage of House Bill, I think it's 2425 this past session, I think some clerks feel that they have the legal authority to do a recording of electronic documents. Much of the Rulona work that we're working on is to kind of spell out how that all fits together. But in the meantime, there might be a way for a county to work with a third-party vendor and create ability to do electronic document recordings. Before having done that like last year or something. So I think it's worth considering adding curative sections like the earlier draft had suggested. And I think, Michael, you since it's in your draft, maybe you should speak to that, and if you think it's something we should pursue.
Yeah, thanks, Cleve. That was something that you and I talked about, Cleve, a couple of years ago. I guess before the electronic recording statute was updated this past session, and that actually would be a change to the Recording Acts, so Statute 93-810, so something outside the notary statutes. But because this Rulona does have a recording provision especially for papered out documents, it may make sense to have a curative provision like has been enacted previously, which simply validates the documents that satisfy this law as it's passed, but may have been recorded before its effective date.
Right.
And I can circulate the language that you and I worked on, Cleve, that would accomplish that. But it's a good point to make.
Okay.
Marissa, is that a good idea, or what's your thought?
I don't comment on the goodness of ideas.
All right. Is it a possible idea?
Yes, it's possible.
Okay, all right. Michael, why don't you circulate that to Sandy, and we'll look at it when we come back with a revised draft.
Okay, great. And Cleve, why don't I send it to you and Craig, because we worked on it a couple of years ago. It might need to be updated a little bit to take into account the passage of the recording bill this past term. So if you don't mind taking a look at that before we send it off to Sandy, that would be helpful.
I'd be happy to do that, thanks.
House Bill 24, 25, is that what it was?
I think that...
2425, Pam, that was credit union bill.
Cam's bill.
Yeah.
Okay, anything else, Cleve, you got there?
No, I think this is kind of a thought that follows up on our discussion on notaries and the question of capacity, because title companies expect the notaries to satisfy themselves that the person signing knows what he or she is signing. And I think besides the statute that Ken referred to, the definition of acknowledgement goes beyond just identifying the signer, but to the statement that by the signer that he or she understands the purpose of what she's or he is signing. So I think there is an element, whether that means you have to satisfy yourself that somebody's mentally competent or it's some other standard. I think that title companies train up their notaries to engage the people that are signing so that you do have a sense that they are signing for the purpose intended. And although there was some leaning in the other direction, I think reinforcing that in a way that would require all notaries, not just notaries at title companies, but all notaries being sensitive to that requirement to make sure the person who's signing knows what she or he is signing.
Okay. Well, I don't know that is going to require any change in what the statute proposes. It may deal with how Secretary of State does the required training. So, am I missing the point there, Cleve? Or?
Oh, well, no, I think that it was, if we're going forward with something more along the Florida model than the current Oregon model, I think it probably would get some support from title companies because we do expect notaries to make inquiries that relate to the capacity and understanding of the person who signed the document.
Well, at least it's my understanding that our current thought process is we're not going to go down the road of a prohibitive statute, and we're just going to stay with the may refuse language that we've already got. But we certainly can raise that issue again for another draft. Anything else?
Good.
Anything else for the good of the order?
I think the last thing for the journal, and it might be done in the rulemaking as well, is if you want the electronic journal to specify it was a wrong closing or not, or if you guys want to put that in the statute to differentiate if someone shows the audit log, which one would have a video versus not, or.
Yeah, we'll have to give that some thought too.
We'll think about that.
Perfect.
There we go. So, where we are is, I think that we're coming back with a more focused draft of what the proposal might be. And then we can hopefully decide if we're going to recommend that this be adopted, and then it'll get to a position for the commission to vote on it, and hopefully it'll be timely for having somebody carry it through legislation.
We have a commission meeting set for October 17th, so if we're able to meet again, look over a new draft and hopefully make a recommendation, we theoretically should be able to have the commission approve a bill for submission for the short session on that date.
Okay.
So I'll put out, for meeting schedule, which is probably our last agenda item anyway, I'll put out some dates to hopefully get a meeting scheduled prior to the 17th, so that's at least a possibility.
Okay. Marissa, is that time?
No problem.
We good. Okay, great.
Sandy, I was just gonna say, it might be nice for those of us, in the building to at least bring some awareness of
Mhm.
who may be coming, even though the law
I think
commission has not voted. What might be good, because of the way session works, it might be good to get the chair to have an informational hearing during January ledge days in preparation for the next session. Because most of the legislation that's going to actually move is going to be legislation that will have had to be heard in front of the committee, or they need to be aware of it. So, even just, Matt and I, and Amy talking to a couple of chairs, just saying, hey, this is coming, would you be willing to put it on an agenda? I don't know if you've talked to anybody about
Let me see, Chan, are you back?
Yes?
Hi, Sandy. Yes, I am.
Could you potentially respond to that question?
Sure. We would actually be able to reserve some time during November ledge days for this topic, as well as in January. In January, one of the things we like to do is line up the bills that we know are going to be in front of the committee and have a brief hearing on them, kind of an introduction to the bill so that everyone is familiar with them before we actually lace up our shoes and start running that fast track of short session. So I think either in November and January, or just one or the other, is a great idea, and we can make that happen.
Shannon, can I ask you, Pam, my bill went to both business and judiciary, business on the House side and judiciary on the Senate side. How do you anticipate this bill?
I think on the Senate side, it would definitely be a Senate Judiciary bill. On the House side, I could see it going to one of the other committees, but there's not enough time for it to go to both. So it's going to be one committee in each chamber. Senate side, I will put money down that it'll be Senate Judiciary. House side, I think there's some debate, but we could probably sway the speaker to send it to House Judiciary if we felt strongly enough about it.
Well, the easier track would be, I think, better.
I don't know if you remember, but I did briefly discuss remote authorization and the efforts of this group with Eric Scheiger. And he's yeah. So he should know some of you remember that it was obviously a very brief meeting, but.
Well, to the extent that anyone wants to have a conversation with a chair, Matt or Pam or Jana or whomever, Amy, let's start talking it up, because it looks like we're going to have a bill, and I would bet that the commission is going to recommend it. With that, so I'm going to leave the scheduling up to Sandy, and I thank you for all of your great comments and work. Looks like we're actually getting to a place where we can get this before the commission and go forward.
And I'll get a scheduling link out there hopefully tomorrow, so we'll be able to set something soon.
So, thanks again, and we'll see you next time.
Thank you, everyone.
Thank you.
Thank you, everyone on the phone.
Thanks.
You.